Hi, I'm Ben Caldwell. Today we're going to be talking about the official BBS sample questions just released in 2024 for the California LPCC Law and Ethics exam. There are 3 sample questions and they give you the correct answers for these questions, but they don't explain why. So today I'll go through those questions and we'll get a clear sense of why the correct answer is the correct answer. Let's dive in. The first one has to do with a colleague who is behaving unethically. An LPCC observes that another mental health professional's behavior with a client violates an ethical standard. Which of the following actions should the LPCC take first to manage the ethical obligation in this case? Now, there are 2 key words in that question I want you to get in the habit of looking for. The first word is ethical. We are looking specifically for an ethical obligation here, not a legal one. And a lot of the questions that you may see on your exam will cue you in this way. They will tell you what they're looking for. Bear in mind that any question on a law and ethics exam is going to be asking about your knowledge in a single specific area. So I know that in clinical practice, we are responsible to all of our legal and ethical obligations all of the time. But for testing purposes, they're asking you about them one at a time. And one of the ways that they can make incorrect answers look more appealing is to have them be things that you might actually do in a particular situation, but that don't answer the question at hand. So you might see a question that asks about a legal obligation, but if your response, even if it's a thing that you would do, addresses an ethical obligation, it's incorrect. So we want to make sure that we're reading the question carefully for those kinds of keywords: legal, ethical. When you're talking about a clinical exam, make sure you're attending to keywords like assessment, treatment or intervention, crisis, that kind of thing. The other key word in this question is first. Which actions should the LPCC take first to manage the ethical obligation in this case? There might be answers here that would reflect a number of things that you would actually do, or at least would consider in this situation. The question is asking about the first step. So, holding those things in mind, let's look at our response options. A, attempt to address the issue with the other professional. B, file a formal complaint with the Board of Behavioral Sciences. C, recommend that the client file a complaint against the other professional. Or D, report the violation to the American Counseling Association's Ethics Committee. We can toss out C pretty easily. We're not going to recommend that the client file a complaint. That decision will be up to the client anyway. That leaves us with A, B, and D. And B and D both involve reporting. B is a formal complaint to the BBS. D is reporting the violation to the American Counseling Association's Ethics Committee. Those are both things that you might ultimately wind up doing, but it shouldn't be your first step. Your first step when you are concerned about the behavior of a colleague is going to be to try to address that behavior directly with the colleague, to see whether there's been some kind of a misunderstanding, to see whether the colleague is aware of their ethical obligations, to see whether it's possible that they might correct their behavior and repair any harm that's been done. The first step when you are concerned about a colleague is always going to be to start with the colleague. Response A here, attempts to address the issue with the other professional, is correct. The next question has to do with the therapist's or counselor's reaction to a particular client situation. A client who was recently treated for breast cancer is referred to counseling by their physician. The client has been experiencing anxiety attacks and extreme mood swings. After 3 sessions, the LPCC begins to have difficulty discussing the client's issues because the LPCC's mother just died of cancer. Which of the following actions should the LPCC take to manage the ethical obligation in this case? With any kind of countertransference issues, we want to make sure that the therapist or the counselor is able to monitor themselves for impairment, to consult or refer out as necessary, and ultimately to provide the client with the best care possible, keeping it about the client and not the provider. So let's see what our options are here. A, discontinue treatment and refer the client to another LPCC. B, seek consultation with a colleague or other professional. C, continue treatment while managing countertransference issues. Or D, use self-disclosure to establish an empathic bond with the client. Let's rule out D first because that centers the therapist or centers the counselor here. While there are times when self-disclosure can be appropriate to build a bond with the client and make clear that the counselor can empathize with the client's experience, in this case, the client would be put in an odd position of potentially having to take care of the counselor. It would be centering the counselor's experience in an uncomfortable way. So we're not going to use self-disclosure here. And self-disclosure doesn't manage the LPCC's ethical obligation. Then let's look at C, continue treatment while managing countertransference issues. That's sort of the answer equivalent of take no action. Continue thinking about it, but don't really do anything else. Considering the severity of the client's symptoms here and the closeness of this issue to the LPCC, since their mother just died of the same kind of illness, continuing to provide treatment doesn't seem to be an adequate response in and of itself. Response C also doesn't tell us what managing countertransference issues would look like. So it's not clear that simply continuing treatment and monitoring would be enough in this situation. We're going to rule out option C. Then we've got A and B left, either discontinue and refer out or seek consultation. So we see that the LPCC is having difficulty discussing the client's issues. We don't know from the question really how much that is interfering with the care. We just know that the LPCC is experiencing some difficulty. Does the client even notice? Is it impacting the effectiveness of the treatment being provided? We don't have that in the question. We only want to refer out when referring out is truly necessary in the best interests of the client. In this case, we don't have enough information in the question to get us there. So the most appropriate step based on the information that we have available is going to be B, seek consultation with a colleague or other professional. In this instance, the counselor is actively doing something to address the countertransference issue, and the colleague or other professional can help them determine whether a referral might ultimately be necessary. But with the information that's in front of us so far, the best step is to seek consultation. Lastly, let's look at a records request when the client has died. A client who had been treated for several years by an LPCC dies. 3 years later, the client's spouse contacts the LPCC and requests a copy of the client's records. Which of the following actions should the LPCC take to address the legal obligation in this case? We know we're looking for a legal obligation here. That's helpful if any of the response options would address an ethical obligation instead. Let's look at our options. A, the LPCC must not release a copy of the client's records. Client confidentiality continues after death. B, the LPCC can release a copy of the records in summary form, omitting damaging statements. C, the LPCC must release a copy of the records to the spouse if the client was legally married to the spouse at the time of death. Or D, the LPCC can release a copy of the records after the client's death if an evaluation shows that no harm could result to the remaining family members. So in these response options, you'll see that 2 of them contain the word must and 2 of them contain the word can. That can sometimes be important when we're thinking about legal obligations. Let's talk about option D here before the others. Option D says the LPCC can release a copy of the records after the client's death if an evaluation shows that no harm could result to the remaining family members. That comes across as just odd. Who would do that evaluation? How would they possibly know enough about the other family members to know what harm could result to them as a result of the release of records? And wouldn't that person need to have also looked at the records to know what might potentially be harmful? It's a weird answer. And this is one that I think we can eliminate simply on the basis of weirdness. That's an odd process to even propose as an option. that leaves us A, B, and C. And we come back to this question of whether that spouse would then have a right to the treatment records. So we think about, what does confidentiality normally look like? If you have a client who comes to therapy on their own and they're married, can their spouse request their records? Well, no. You wouldn't provide records to the spouse without a release. The client's confidentiality does continue past their death. There's no kind of an exception or waiver in the law for when a client has died. So, in the absence of having a release from the client to provide records to their spouse, you can't do it. A is the best option here. The LPCC must not release a copy of the client's records. Client confidentiality continues after death. And that is, in fact, the one that is correct. You might reasonably think, well, what if the spouse goes and tries to get a court order as the next of kin or the executor of their estate? They can try to do that. Let them sort that out in court. If you simply are receiving a request from the client's spouse after they died, and that's all the information that we have to go from, then you don't release the records. Hopefully you saw that those 3 questions weren't too bad. It's not too difficult to parse out those samples that the BBS offers. My program that will provide you with prep for the California LPCC Law and Ethics exam includes 2 full-length practice exams as well as a mini-mock, more than 200 practice questions in all with complete rationales, and it includes exclusive reporting on your test-taking skills. Are you able to effectively parse out which answers are right? How do you do with changing answers or flagging items to come back to? How's your time management? And when you make mistakes, what's the best way to resolve those mistakes? Our test-taking skills report addresses these elements and many more. So please check out our program at highpass.com. Once again, I'm Ben Caldwell. Have a good day.